Hey, it's your girl, your favorite paralegal, aka Sandra Lynn, and welcome to Legal Doc Talk 24/7. Hey, y'all, so this is an update on Eric Adams' trial. If y'all do not know, Eric Adams was actually um, found, well, I don't want to say found guilty. He was charged with bribery and fraud while in the capacity of a New York City mayor. And he was set to go on trial on I believe it was April 21st, if I'm not mistaken. But guess what? So the court heard his case on, or had a hearing on this past Wednesday for the DOJ. And if you don't know who the DOJ is, that's the Department of Justice. The interim actually ended up sending the court a letter asking them to dismiss Eric Adams' case. All right. So that took place, and guess what the court decided to do? Now, this is also in the Southern District of New York. Eric Adams' lawyer is Alex Spiro. And Spiro has been criticized on the way he has been handling this particular case, and the judge had to be on him. But guess what the court did? So this judge, Judge Dale Ho, on February 19th, 2025, the court held a conference on the government's motion to dismiss the indictment in this matter under Rule 48. In light of the government's motion and the representations of the parties during the conference, it is clear that the trial in this matter will not go forward on April 21st. Accordingly, trial is now they actually misspelled this last part, but it's adjourned sine die. The order setting a pretrial schedule is hereby vacated. All of the deadlines are also adjourned, and that means that no. So they're saying that it is. How can I say this? It's in the case is dismissed. Not even dismissed. It's like on pause or a hold indefinitely with no further set court hearings or settings or providing another trial date. It's just there. Now, in the event they can come later on down the line to pick this back up and say, okay, let's go ahead and schedule court on this, well, not court, trial on this particular date. So that is what this pretty much means, okay? It goes on to say that normally courts are aided in their decision making through our system of adversarial testing, which can be particularly helpful in cases presenting unusual fact patterns or in cases of great public importance. Our legal system assumes that adversarial testing will ultimately advance the public interest in truth and fairness. In particular, the unique strength of our system of criminal justice is that it is premised on the belief that truth is best discovered by powerful statements on both sides of the equation. And then they cited United States versus Chronic, as well as Young versus the United States, where it stated in that particular case that the public interest that a result be reached with which promotes a well ordered society is foremost in every criminal proceeding. Our judgments are precedents, and the proper administration of the criminal law cannot be left merely to the stipulations of the parties. For example, in the context of Rule 48A of the motion, the government's request for dismissal without prejudice is often contested by the defendant and then adjudicated by the court with the benefit of adversarial briefing. And then it says here the recent conference helped clarify the parties' respective positions, but there has been no adversarial testing of the government's position generally or the form of it requested relief specifically. Whereas here, nominal adversaries are aligned in their positions. Precedents and experience have recognized the authority of courts to appoint an amicus to assist their decision making, including in criminal cases and even when the movement is the government. Then it goes on to say, similarly, district courts have broad discretion to permit or deny an appearance as amicus curiae in this case. And then let me see. And it says, and there is a precedent for the appointment of amicus to assist a district court in the consideration of an unopposed motion under Rule 48A specifically. And then lastly, it says, accordingly, to assist with its decision making via an adversarial process, the court exercises its inherent authority to appoint Paul Clement of Clement and Murphy PLC as amicus curiae to present arguments on the government's motion to dismiss. Then it says that the court expresses its gratitude to Mr. Clement for his service and will provide Mr. Clement a copy of this order and the transcript from February 19th conference. It is hereby ordered that the parties and amicus curiae shall address 1. The legal standard to leave, or the legal standard for leave to dismiss an indictment, whether and to what extent a court may consider materials other than Rule 48 motion itself, under what circumstances, if any, additional procedural steps and or further inquiry would be appropriate for resolving a Rule 48 motion, and to under what circumstances, if leave is granted, dismissal should be with or without prejudice. 5. If leave were denied under Rule 48, what practical consequences would follow, including whether dismissal would nevertheless be appropriate or necessary under the other rules or legal principles, or under speedy trial principles. And 6, any other issues the party or amicus considered relevant to the court's resolution of the government's motion. So briefs shall be due no later than March the 7th. If necessary, the court will hold an oral argument at 2 p.m. on March 14th. The court notes that it has considered the parties' views with respect to the appointment of amicus and concluded that an appointment is appropriate here to assist the court's decision making. That is particularly so in light of the public importance of this case, which calls for careful deliberation, because we are all trying to figure out, like, why hasn't this man been prosecuted for defrauding? Because pretty much it was to his benefit. So he took briberies, he committed fraud in order to uh make sure that his bag was still good. Okay. But I don't know what happened between during Trump's election, but it was alleged that he was trying to get in Trump's good graces in order to get this, pardoned. He attended the inauguration. He actually went to Mar-a-Lago to, speak with Trump. So we don't know what was done on the back end and what the case may be, but we're trying to figure out, why should the court consider this particular motion to dismiss that has come down from the Department of Justice? Because it does not make sense. It makes sense. It doesn't make sense. So you have the government wanting to sue a man because he committed fraud and accept bribes. But yet you have the same government come and say, oh, we need to dismiss this case. Which one is it? So we have to have somebody, think of it as a liaison or a mediator to come and express as to why does this motion to dismiss, why should this case be dismissed, period? Because us, the people, I'm not in New York, but I feel like there are a lot of people that are getting in trouble for either trying to make sure that they bag stay good by working with the wrong people. They're committing fraud, they're stealing money. Like, they should be brought to justice. What makes Eric Adams any different? Anywho's, it says the court reiterates that it understands the importance of prompt resolution of the pending motion and whether endeavor to rule expeditiously after briefing is complete. The adjournment of trial and all related deadlines alleviates any prejudice resulting from a short delay. Moreover, in light of the concerns raised by parties regarding the mayor's responsibilities and the burdens of continued court appearances, the court notes that while Mayor Adams has a right to appear at any future proceedings, he need not do so given the current procedural posture. In other words, absent Absent an order of this court stating otherwise, Mayor Adams need not appear and need not file a notice voluntarily waiving his appearance at future proceedings, if any, on the government's motion to dismiss. Meaning that they're going to continue with this motion to dismiss, but somebody has to come in and really explain the reason why this whole indictment needs to be dismissed. But if there are any hearings, Eric Adams does not have to attend. He can continue to handle his mayor duties for the city of New York. Finally, in light of Mr. Clement's appointment as amicus, the court does not believe there is a need for any additional amicus participation at this stage. Nevertheless, to ensure that the parties and the appointed amicus have an opportunity to respond to arguments made by the other amici, if any motion for leave to participate as amicus must be filed with the proposed amicus brief by February 28th, or that's in 5 days. The court will not consider any motions for amicus participation after that date. Any opposition to such motion by a party shall be filed by March 5th. So once again, so although they put a pause, that's all they did is they put a pause on this case, but have not set any future dates. Okay. All hearings, all deadlines have been vacated. They are canceled. Canceled. As of right now, their focus is on why this case should be dismissed. That is the argument here. That is the argument. In the comments below, knowing that this man allegedly took bribes, committed fraud just to keep his bag intact, do you feel that the government is right? Now, this is the same government that wanted to try him. Is the same government that is asking for this case to be dismissed. Make it make sense. Tell me your thoughts in the comments below. Don't forget to like, share, and subscribe. Until then, you all be blessed and I'm out. Bye.